What happens when a president's personal lawyer becomes the nation's top legal representative before the Supreme Court? That's the question at the heart of a recent Senate confirmation hearing that has sent shockwaves through Washington. Senator Adam Schiff confronted John Sauer, President Trump's nominee for Solicitor General, in an exchange that exposed deeply troubling positions about presidential power, legal ethics, and the independence of the Justice Department. This wasn't just another routine confirmation hearing. It was a stark revelation about how far the boundaries of executive authority might be pushed under this administration. The implications reach far beyond the hearing room, touching every American who believes in the rule of law. Let's break down exactly what happened, what was said, and why it matters for the future of American democracy.
The hearing began with what should have been a straightforward question. Senator Schiff asked Sauer whether he would recuse himself from cases involving President Trump, given that Sauer had served as Trump's personal defense attorney. It's a basic ethical principle. Lawyers don't judge cases involving their former clients. Sauer's response seemed reasonable at first. He said he would consult with Department of Justice ethics officials and follow all recusal obligations as outlined in the ethics agreement he signed and in DOJ regulations. For anyone unfamiliar with recent developments at the Justice Department, this might sound reassuring. But Schiff wasn't about to let that answer slide without scrutiny, because the reality behind those words tells a very different story.
Senator Schiff immediately challenged Sauer's response with a devastating fact. The career ethics officials at the Department of Justice have been systematically removed from their positions. These were nonpartisan professionals whose job was to provide independent ethical guidance, ensuring that political considerations didn't corrupt legal decision-making. According to Schiff, they've been fired, demoted, or transferred. What remains of the ethics office? Just two people. One is a fellow criminal defense lawyer who represented Donald Trump, and the other is a recent law school graduate who is a political appointee. This isn't an ethics office in any meaningful sense. It's a rubber stamp operation. When Sauer said he would consult with ethics officials, he was essentially saying he would ask Trump's allies whether he should step aside from Trump's cases. That's not ethical oversight. That's political theater.
Sauer claimed he wasn't aware of the personnel changes that Schiff described. This response is problematic for several reasons. First, if Sauer truly did know about these significant changes to the ethics infrastructure at the department he's being nominated to serve, that raises serious questions about his preparation and awareness. Second, it's difficult to believe that someone as deeply connected to the Trump legal team would be unaware of such major personnel actions. Schiff didn't accept the deflection. He made it crystal clear that these changes had indeed taken place and that the people who would be making recusal recommendations to Sauer were political appointees with direct ties to Trump's legal defense team. This creates an obvious conflict of interest that undermines any claim of independent ethical review. Then came the most explosive moment of the hearing. Schiff brought up an argument that Sauer had made while representing Trump in the D.C. Circuit Court of Appeals during the presidential immunity case. Sauer had argued that a president could order SEAL Team 6 to assassinate a political opponent and could not be prosecuted for that action unless he was first impeached and convicted by the Senate. Let that sink in for a moment. According to this legal theory, the president could use the military to murder a rival politician, and the only consequence would be if Congress decided to remove him from office first. Criminal prosecution would be off the table. Schiff asked Sauer directly whether he still stood by that position and whether he would continue to defend that interpretation of presidential power as Solicitor General representing the United States. Sauer tried to dodge the question by reframing it, but ultimately he reaffirmed his position. He explained that under his reading of the Constitution's impeachment judgment clause, a president must first be impeached and convicted before facing criminal prosecution for official acts. Schiff pressed him on what this meant in practice, that a president could order violence against a political opponent and be shielded from prosecution unless Congress acted first. Sauer attempted to deflect by bringing up President Obama's authorization of drone strikes that killed American citizens abroad who were engaged in terrorism. But Schiff wasn't asking about legitimate military operations against terrorists. He was asking about using presidential power to assassinate domestic political rivals. Sauer called the hypothetical outlandish, but never actually rejected the legal principle underlying it. This isn't just an abstract legal debate. The theory Sauer defended has profound real-world consequences. It essentially places the president above the criminal law as long as he's in office and hasn't been impeached. Under this framework, a president could commit virtually any crime, including violent crimes, and claim immunity from prosecution. The only remedy would be the political process of impeachment, which requires a two-thirds vote in the Senate for conviction. This creates a situation where presidential power becomes effectively unchecked by the criminal justice system. When Schiff pointed out that Sauer had defended this position in court, but wouldn't clearly address it in the Senate hearing, Sauer insisted he was giving the same answer. That answer, however disturbing, was consistent. Presidents can act with impunity unless Congress removes them first. Schiff then turned to a recent scandal involving the Department of Justice's handling of a corruption case against the mayor of New York. According to Schiff, the acting U.S. attorney for the Southern District of New York refused to dismiss the case because she believed doing so would be deeply unethical. The pressure to drop the case then fell to her deputy, Edward Hayden Scotton. Scotton wrote a remarkable letter explaining his resignation from the case. He stated that any U.S. assistant attorney would know that American laws and traditions do not allow using prosecutorial power to influence citizens, especially elected officials, for political purposes. He wrote that if no lawyer within earshot of the president was willing to give him that advice, the president would eventually find someone foolish or cowardly enough to do his bidding, but it would never be him. Schiff asked Sauer point blank, would you be that person? Would you be willing to dismiss a case on behalf of the president even if you believed it was unethical? Would you use your position to carry out the president's political agenda rather than upholding the law impartially? Sauer refused to answer directly. He said he couldn't speak to hypothetical scenarios and what actions he might or might not take. Instead, he tried to turn the question around by suggesting there had been a distressing lack of such principled letters during what he characterized as the weaponization of justice under previous administrations. But this deflection only highlighted his unwillingness to commit to the basic principle that prosecutors shouldn't manipulate cases for political purposes. Senator Schiff's response was withering. He told Sauer that his refusal to answer the question was itself an answer. The silence spoke volumes. Schiff said that his colleagues had praised Sauer's legal skills, and he didn't doubt Sauer's knowledge of the law. But then came the crucial point. You can't be a good lawyer if you use the law to subvert the law. You can't be a good lawyer if you use the legal system to undermine the legal system itself. Schiff expressed deep concern that this is exactly what Sauer had done as Trump's personal attorney, and it's exactly what he would continue to do if confirmed as Solicitor General. This wasn't just criticism of Sauer's legal positions. It was a fundamental challenge to his fitness for the office he seeks. Understanding why this matters requires understanding what the Solicitor General actually does. This isn't just another lawyer position at the Department of Justice. The Solicitor General is often called the 10th Justice because of the office's unique relationship with the Supreme Court. The Solicitor General represents the United States government in cases before the Supreme Court, arguing on behalf of the federal government and determining which cases the government will appeal to the High Court. The office has traditionally maintained a reputation for independence and integrity, even declining to defend government positions that lack legal merit. When the Solicitor General speaks before the Supreme Court, the justices listen with particular attention because the office has historically been trusted to present honest, well-reasoned legal arguments rather than purely political positions. That tradition is now at stake. The concerns about Sauer's nomination fit into a broader pattern that has emerged in this administration's approach to the Justice Department. Career prosecutors and ethics officials have been pushed aside. Political appointees with personal loyalty to the president have been installed in key positions. Cases that might implicate the president's allies have been dismissed or undermined, while investigations into the president's perceived enemies have been pursued aggressively. The independence that has traditionally characterized federal law enforcement is being systematically dismantled. Sauer's confirmation would represent another step in this transformation. Instead of a Solicitor General who views the office as a sacred trust to represent the rule of law before the Supreme Court, we would have a Solicitor General whose primary loyalty appears to be to the president who appointed him. Let's examine Sauer's constitutional argument more closely. He relies on the impeachment judgment clause, which states that officials convicted in impeachment proceedings shall nevertheless be liable to criminal prosecution. Sauer interprets this to mean that impeachment and conviction must come before criminal prosecution. But constitutional scholars have long debated this interpretation. Many argue that the clause simply means impeachment doesn't preclude later criminal prosecution, not that it's a prerequisite. The practical effect of Sauer's interpretation would be to make criminal accountability for presidents nearly impossible. Given the partisan nature of modern politics, achieving a two-thirds Senate majority to convict a president of one's own party is extremely unlikely. This interpretation effectively grants presidents immunity from criminal law while in office, regardless of what crimes they might commit. Past Solicitors General from both Republican and Democratic administrations have sometimes refused to defend government positions they believed lacked legal merit. They've acknowledged limits on executive power and have argued for positions that didn't always align with what the president might have preferred politically. This independence has been seen as essential to the office's credibility before the Supreme Court. The justices need to trust that the Solicitor General is presenting genuine legal arguments, not just advancing whatever position serves the president's political interests at the moment. When that trust erodes, the office loses its effectiveness and its moral authority. The question before the Senate isn't just whether Sauer is qualified as a lawyer, but whether he would maintain the independence that has defined the office or subordinate it to presidential politics. The destruction of the Justice Department's ethics infrastructure deserves particular attention because it affects every decision the department makes. Ethics officials serve as an internal check, ensuring that prosecutors and political appointees don't abuse their power for partisan purposes. They provide guidance on recusals, conflicts of interest, and proper procedures. When these officials are replaced with political loyalists, that check disappears. Decisions that should be based on law and precedent become based on political calculation. The question of whether Sauer should recuse himself from Trump-related cases becomes not a matter of independent ethical judgment, but a matter of asking Trump's allies whether Trump's interests would be served by Sauer's recusal. This isn't how justice is supposed to work in a democracy. It's how it works in authoritarian systems, where the law serves the leader. The implications extend far beyond any single case or controversy. At stake is the fundamental principle that no one, not even the president, is above the law. If the president can commit crimes with impunity as long as his party controls enough Senate seats to prevent conviction, then we don't really have the rule of law. We have rule by the powerful, constrained only by political calculations, rather than legal principles. If the Solicitor General uses the prestige of that office to advance theories of unlimited presidential power before the Supreme Court, those theories might eventually become established law. The Supreme Court has already shown a willingness to expand presidential immunity in its recent decision in Trump v. United States. A Solicitor General arguing for even broader immunity could push the court further in that direction, fundamentally reshaping the constitutional balance of power. The Senate now faces a critical decision. Will senators vote to confirm someone who has demonstrated willingness to advance legal theories that place the president above criminal accountability? Will they approve a nominee who refuses to commit to basic ethical principles like not using prosecutorial power for political purposes? This isn't a partisan question, though it will likely be treated as one. It's a question about the kind of legal system we want to have. Senators who care about the independence of the Justice Department, the integrity of federal law enforcement, and the principle that no one is above the law should think very carefully before voting to confirm John Sauer. The office of Solicitor General is too important to entrust to someone whose primary qualification seems to be loyalty to the president rather than to the Constitution. The exchange between Senator Schiff and John Sauer wasn't just another political theater moment in Washington. It was a revealing glimpse into the legal philosophy that would guide the nation's top Supreme Court advocate if Sauer is confirmed. The refusal to commit to basic ethical principles, the defense of virtually unlimited presidential power, and the unwillingness to maintain independence from political pressure all point in a troubling direction. As citizens, we should pay attention to these confirmation hearings. They're not boring procedural matters. They determine who will hold power over our legal system and whether that system will serve justice or serve the powerful. The decisions made in the Senate today will shape American law and democracy for years to come. This is a fight that matters, and we all have a stake in its outcome.